Hi, Deirdre Verbo here with Let's Talk Seniors, Memory Care Issues, Alzheimer's, Dementia, and Parkinson's. Thank you so much for joining us today. Today we have a very special guest. It is Ann Fowler Cruz with Cohen and Wolf, and I will tell you a little bit about Miss Ann. I coincidentally met her about 5 years ago, and we just found out the other day that we had known each other. So Ann, who lives in Newtown with her husband and daughter, has been a staunch advocate for the elderly and disabled for more than a decade. She has the distinction of being a certified Eldercare law attorney and the National Elder Law Foundation, and is accredited to practice before the Department of Veteran Affairs. Her extensive knowledge in the area of elder law enables her to assist the elderly and the disabled in realizing the very best quality of life. Her elder law practice focuses on long-term care planning, asset preservation strategies, Medicaid applications, disability planning, utilizing conservatorships, guardianship, and special needs trusts. Her estate planning practice includes the creation of wills, trusts, and advance directives, and also handles probate administration. So everything elder care and more. So without further ado, we are going to welcome Miss Ann Fowler Cruz.
Thank you,
Hi,
Deirdre.
Ann, how are you?
Good, nice to see you.
Yeah, it's pretty funny that I remember, not funny that I remembered meeting you, but it was funny I remembered meeting you in person about 5 years ago on site of a property of probate that you were handling for an elder client, an elderly client. So I see that I'm a little delayed here. I don't know why, but I know that you got into law a little later after managing restaurants and all. What was the reason? Like, what drove you to go into law, and in particular, elder care law?
So I think I am a people person. I'm a good listener. I'm a problem solver. And so with my prior career, I was in the service industry, again, dealing with customers and people. I decided to go to law school, thinking, again, just another level of helping people. When I got to law school, wasn't quite sure what I wanted to do. Dabbled, tried different areas. I slowly crossed things off my list. I didn't want to do divorce. I didn't want to do personal injury. And then I finally settled into elder law for two reasons. One, again, it's helping, it's listening. It was a great area. I knew it was also going to be a burgeoning area with the baby boomers. And at the same time, when I was in my third year of law school, my mom was diagnosed with Alzheimer's. And I said, this is a sign. So I was my own client in the very beginning, kind of walking through that process with my mom. And ever since, I said, this is where I'm supposed to be. I'm very lucky in that I love what I do.
Wow. So with your mom, was your dad still alive when she got diagnosed?
Yep. He was the caregiver. He took care of my mom for probably 7 years before she passed.
Wow.
So again, trying to protect the spouse, protecting the ill spouse and the healthy spouse. So it's really quite a dynamic relationship and taking care of both of them and their different needs. So again, I saw it firsthand and said, wow, and helping families, as you do, navigate. There's so many things out there that they don't know. So I try to help families navigate amongst other services as well.
Yeah, I find, and let me know if you find this, so people don't know what they don't know. They don't even know there's a way to protect. They don't even know there's other options. They don't even know there could be monies out there. They don't even know there's a way to protect their assets. Do you find that true? They don't even know to come to you.
That's true. It's like entering a foreign world. and you don't speak that language, where do you begin? It's the learning curve is just unbelievable. Nursing home, assisted living, continuing care communities, there's just a whole terminology, that you get into. So you're right. I spend most of my time, kind of as we're doing now, in trying to educate and spread the word, and let people know, at least, oh, I heard, or I remember hearing, just to kind of get the word out and educate people as to, what's out there.
Nice. So I think this is a place of mystery, what we're going to talk about today, spousal protection in the event of long-term care. Let's start with, is it always available to everybody, and who can be protected?
Sure. So when we look at long-term care, what does that mean, right? It can mean many different things for different people. So typically when we talk about long-term care needs, it's when you have someone who needs help with activities of daily living, right? ADLs, as we call them: bathing, dressing, feeding, grooming, transferring, more frail issues, or dementia and confusion. So when we talk about that specific type of care, again, who help, what sources of payment are there? We have Medicare. I always say, because the federal government cares. We have a tiny, tiny sliver of benefit for activities of daily living and custodial care. If that's through rehabilitation, you can get the hook and get some help in the home or in the nursing home during rehab, but it's very short term. There's the VA. Perhaps there's a benefit through the VA that families might be eligible for. There's hospice, there's respite. Maybe someone has long-term care insurance. That will help defray the cost of care. And then we have Medicaid, which is more like financial aid. You have to show that you're eligible financially for that program. And if you can meet those qualifications, then we can bring in the services. And through the Medicaid program, covers the nursing home in full. And I'm knocking on wood here, potentially 24-hour home care is possible through the Connecticut Medicaid home care program.
But if you have a spouse and you have a house,
spouse and house,
how are they protected?
Sure.
How is it there? Like, let's say you have a young, your wife is 60 and you're 85, or, whatever it is. You don't have to be that much older, but just in case. And, your wife is going to need longer protection, and, you're failing in health. And how are the assets protected so everything is not used up in your care?
And that is a classic worry. Obviously, the average cost of a nursing home is $15,000 a month. To 24-hour live-in care can be $10,000 a month. So absolutely, we want to make sure the ill spouse is taken care of, but not to the detriment, to the destitution of the healthier spouse. So absolutely. So the programs, the Medicaid program does provide some safety nets and some securities for what we call the community spouse, the healthy spouse. And so some of the myths you hear out there is, I'm going to lose my home. Well, no. The home is not counted for eligibility if there's a healthy spouse living in the home. They will not lien it. They will not take it. It is sacrosanct. The home is safe. And the home of any value. Okay, so there are some rules out there that if you're single, your equity can't be more than $800,000. But again, if it's a spouse, there's no cap on that equity. So the home is safe. Whew. And there are other exempt assets, your car, your personal property, that sort of thing. And then the general rule, and I like to say the general rule because it's all about exceptions to the rule in this area. The general rule is the healthy spouse can keep half the assets. Now, when we talk about that sentence, half the assets, so because they're a married unit, what's his is hers and hers is his. It's all put into one pot. So everything but the house is taken out, right? So the pot is IRAs, 401s, life insurance, stocks, bonds, banking, everything they own. The rule is the healthy spouse can keep half at the time of institutionalization, but don't get too excited. The cap is about 130,000. So you can't keep more than 130. So that would be 260.
So,
right? And the floor is 25,000.
And do you have to do this in a trust, or is this just everybody?
These are just, yeah, so these are the basic rules. If and when you apply for Medicaid, right, that you will not be eligible until you are down to that whatever magic number is. So there's plannings to how do we get to that number sooner than later, right? Are we in crisis? What are our strategies if we're in crisis? And then if we're not in crisis planning, then there are other opportunities to plan through the use of a trust or something like that. So once you know what the game rules are, we can kind of play with the rules and figure out how to protect the assets.
Okay, so could you like pay down your mortgage? So let's say you have $500,000 in assets, and now, and you have a large mortgage that is going to be hard to pay without your spouse's contribution.
Absolutely.
Could you pay down
like
with
that?
Some,
yes.
Is there is there a 5-year look back for that?
So the answer is yes, you could just pay down the mortgage and become eligible. In that hypothetical, that's perfect solution. The other rules that we have to know to work with is when you apply for Medicaid, they look back 5 years to see what you've done with your assets. It's just an audit of 5 years. And they simply are looking to see if you've given away your money in that 5-year period, right? That's really what they're looking for. Give away. All right, you can spend your money. It's just when you give it away, don't get anything back in return, that Medicaid will impose a period of ineligibility and say, shame on you, you're giving money away and now you want us to pay your bill? So that's why we try and, that if you're in crisis, we can't give assets away because we may need care in the 5-year period. So paying down a mortgage is not a giving it away, is it? It is paying a debt, a valid debt on the home. So that is certainly one way to quote unquote spend down or get to that eligible number is spending it. So I jokingly say to my clients, let's go shopping. Let's go to the casino. You can spend your money and get down to that eligibility number. They don't want to take me shopping most of the time, and that's okay. But they can do things like,
suggestion. I don't know why.
That might have been a good plan. Really. But the mortgage, or how about, the roof, the furnace, the driveway, home improvements. Again, that home is exempt. So why not take vulnerable dollars and protect it into an asset that's exempt? It's a great planning tool.
So you can fix your house in case of an inevitable sale to get more money afterwards.
Exactly.
What if your spouse goes into, okay, so let's say you do all this and now you're left with a beautiful home and $130,000 in the bank, and your spouse is happily in a nursing home, and then you go to sell your house and now you have $1 million. What happens?
Another myth, right? So once you have gone through the Medicaid eligibility process, I like to say you've paid your dues, right? The husband's on Medicaid, you have your home, you have your 130, you've paid your dues. And once he's approved for Medicaid, financially, you're no longer liable. I like to tell clients you could win lottery the next day.
Wow.
And that really won't impact his Medicaid eligibility. So you could sell the home, downsize, move in with your daughter, whatever the case may be. Those funds are yours.
Wow.
Yeah. And people, these are the things people don't know. Now, every case is different. One of the other things I tell clients, don't listen to the noise out there, because really every case is different and the strategies will be different. Depends if you have $500,000 or you only have $40,000. So the baseline rules are the same, but the techniques or the tools that we're going to use are very, very different.
Now, so what if in the last 5 years you gave money away? Let's say you gave money to your kids, $10,000, $20,000, they got married. Is there a rule of what you're allowed to have given?
So you're very good. So people again think you can give away $15,000 per person per year, right? That's a tax. You can give it away and not pay a gift tax. We have to finish that statement. Yes, you can give it away and not pay a gift tax. But we're talking Medicaid. So now we're saying something different. Can I give away $10,000 every year and get Medicaid? Most likely not. You will potentially be punished, penalized for doing that. There are
So
some.
what is the gift tax that you can give away? How much can you give away per year
For,
with
without a gift tax complication, gift tax complication, it's $15,000 per person. You
per
can
person?
give away, yeah, everybody give everybody $15,000 and not pay a gift tax.
The person doesn't have to pay it, the giver or the receiver?
Neither.
Wow. I've
Neither.
tried to tell my parents about this, but they never bought into it.
Right. Go ahead. Free. It's free, tax free.
Maybe I should bring it up again. Maybe I should bring it up. No. Okay.
There you go. The lawyer said it's tax free.
What happens if you do something like that? Let's say you gave your kid $15,000 a year for the last 5 years, and now all of a sudden you want to do Medicaid. Do you have to wait 5 years? Do you have to recapture $75,000? What are you doing? How do you fix that?
Those are some of the really tough questions. I think it also may depend, where in the 5-year period we are, right? Every case is different. Let's say we gave us $75,000 away 4 years ago. So now we only have 1 more year to get through, and maybe we're spending down, and instead of paying off the mortgage, maybe we pay for care. If you gave $75,000 this year and you need Medicaid, in 6 months, well, maybe we say, kiddo, I need that money back. But there are exceptions again to the gifting. You can gift to a disabled child. So there are some exceptions to those general rules, right? The general rule is you give money away, Medicaid may impose a penalty period. But again, you can gift to a disabled child. There are a couple others.
So it's a penalty period.
Penalty period is based upon the amount of money you gave away. And Medicaid simply says, you're in the penalty box, and we're not going to pay for your care for X months. And the more you give away, the longer the penalty period is.
Gotcha.
So that's a tricky one when we cross that all the time. And again, there are other exceptions to the rule. So for example, 60-year-old working, healthy, paid for the daughter's wedding and then has a heart attack or a stroke. Well, that wasn't done for the purposes of qualifying for Medicaid. He was healthy. So that we may be able to overcome the burden of proof. The burden is on us to show we didn't do it for Medicaid purposes. So it's a challenging one. I never love those cases because Medicaid just simply says, nope, you're in the penalty. You're in the penalty. So, and it's challenging. So
if your husband, let's say, is elderly and he has a lot of money in his 401k or his, should you be moving it over to yours? Is there any reason to?
So I think my initial response will say, don't do it. Because when you take money out of your 401 or your IRA, it's income taxable, right? So I'm not sure we want to take that income tax hit initially. Now, if we're in a crisis and the spouse is in a nursing home, maybe that is an option. Cash out the IRA and move the proceeds over to the healthy spouse. It is definitely a strategy. It absolutely is a strategy. One of the other ways is the healthy spouse, let's say, has a 401, right? That's counted for Medicaid purposes. One of the tools that we use now that works quite nicely is if we annuitize that IRA, we turn it into an income stream in almost like a pension. That now converts an asset to an income stream, which income isn't counted for Medicaid purposes. So the healthy spouse can keep all of, her income in our scenario, right? She could be working. She could be annuitizing her IRA. She gets to keep her income. You just may lose some or all of the ill spouse's income.
Hold on. So does it make sense to just, let's say you're two people that are on the older side,
Yep.
to keep 130 liquid, let's call it, and annuitize the rest of your money?
That is a crisis planning tool. Yes.
Oh, that's a
It is.
crisis.
Yeah, it's not a good financial tool. You would never annuitize your IRA, most likely, especially because there are some restrictions in order for it to qualify for Medicaid purposes. One of the downsides to this annuity, now you'll know why we don't do it unless we're in crisis, is that if the annuitant, that the healthy spouse here in our scenario, should pass away during the term of the annuity, the state of Connecticut is the beneficiary for payment rendered on the husband's behalf. So, it's not great, but, we can make the term short enough, right? Maybe the life expectancy is 20 years, we make it 10. So there's all different nuances to this, but the bottom line is there are strategies. And again, it depends. Is it an IRA? Is it non-qualified? What's the age? So all of those very fact-specific questions will really dictate, how the strategies are structured. But
oh, sorry. I was going to ask if people needed a trust, or is that not necessary? Is a trust beneficial?
Yeah. So I always ask my clients, what's your goal? Why do you think you need a trust? Trust is a generic term. Trusts are used for many, many different purposes. Typically in the asset protection area in long-term care planning, a trust is a vehicle we use to give assets away. I'm going to give assets away and hunker down for 5 years or more, right? And then if I need Medicaid says, what do you own? And because I gave that away 5 years ago, I don't own it. So as opposed to giving your house to your kids, right? You've heard you've heard them say, I'm going to quit claim the house to my children. Don't do it. There's some really negative consequences to that, right? They own it. Their creditors can attach it. Divorce, personal injury, bankruptcies, right? You're merely a tenant. Taxes, capital gains. I mean, it's really not the best way to do it. But the use of an irrevocable trust may be a really good way to protect the asset. So irrevocable trusts are used to protect assets, but we have to hunker down potentially for that 5-year period or so.
So interesting. My mother-in-law, who just passed with dementia last year, she had 15 years. It's okay. She was 93. It was her time. But they sold her home and put it in trust for the 5-year look back. But they put in the trust to be used for her care.
Oh.
And it was meant to be used for her care, but they had to not put that in. So they did it in New York, and they applied for Medicaid. She, we used her money for like 8 years, and then she had to go to a nursing home, and applied for Medicaid in New York, got turned down. Applied for Medicaid in Connecticut, got turned down. So, she had recently died. So my kids sent me the trust, and I was like, the one line I have to put in there, because I think people don't understand, and you could explain better what I'm saying.
Right.
What you should not put in when you put your house in a trust, even though the assets are for your living, if you put that, now they all get to be used for your living, right?
Yeah, so absolutely. I mean, and that's why you need to hire if you're really doing this type of, this is what you want, you really need an elder law attorney who knows the proper wording, which is very different than an estate planning attorney in some cases. But saying for my support and maintenance means it's available, use it, right? Medicaid says, what do you have? Oh, you have a trust that's available for your health and your maintenance? Bring it on, right? So when you're doing it this way, and I say it 100 times to my client, you're giving away the house. It's not yours anymore. It's in this trust, but you don't own it. Maybe you can rent it and live in it, but it's not really yours anymore. So, that's
I think if they just had one line which, it seems to go against your grain, right? Because it was really for her care. But to put in the line, this is not for her care. If they
Right.
put that in, they could use it for whatever they wanted.
Yeah.
Which would be
Potentially.
for her
In New
care.
York, especially. Yes. Yeah.
But they put in, it was to be used for her care. And so they were shocked that they didn't understand. So they were shocked when they didn't get Medicaid, because that's why they made the trust. Otherwise, there was no reason if they were just going to spend all her money to make a trust.
Ouch. Yeah.
I know. And she was also in a nursing home for, I don't know, 5 or 6 years in a memory.
Wow.
It was in a memory care nursing home. Yeah, it was, yeah. So
Yeah. Yeah.
you have to go to somebody who knows what they're doing. And I'm sure she wanted it for her care, which is true, but you cannot say that. You just have to tell your children that.
Right. And, some people don't want to give their assets away, and that's fine. The kids may want you to, like the gifting. The kids may want you to do that planning, but, not everybody wants to do it. And that's their choice. But, most people are trying to protect the assets they've worked so hard for, right?
So when should people come to you, Anne? I feel like most people probably come to you in a crisis, like, oh my God, my husband got sick. What do I do? My wife is sick. How do I protect myself? When should they come to you?
Well, in a perfect world, again,
Don't we live in a perfect world? What?
If the goal is to protect assets, for our children, our heirs, and our family, then we need to think about doing planning when we are still healthy and we think we can withstand a 5-year period or so. Most of my non-crisis planning clients are probably going to be in their 70s or so. I find people in their 60s or, they've worked hard for their money. They want to spend it and enjoy their retirement. And I say, fine, enjoy. And then I think after they've retired for a while and see that they're going to be fine, the concept of giving it away or protecting it is a little more palatable. So I'd say certainly, if your health is good, 70s is a good, sweet spot, so to speak, to do planning.
It makes it harder, though, if you want to, let's incorporate long-term care. It gets to be astronomical if you haven't thought about that. Now you're thinking about that when you're 70. I think there's some sort of cutoff that you can't even get.
So, Deirdre, that's a really important point. Long-term care insurance is a wonderful tool to help defray the cost of long-term care. And that has to be considered even earlier, right? Maybe 40s or 50s, because as you get older, your premiums are going to go up, and then your health is probably going to deteriorate a little bit as you get older. So long-term care, I think, provides a lot of flexibility. You don't have to give your asset away. You have an insurance to help defray the cost. So that's going to be in your 40s and 50s, maybe 60s. If that doesn't work, if the premiums are too expensive, you can't afford it, or you're physically not able to get it health-wise, then this trust is probably the next layer of planning.
So, Anne, I did a show on long-term care insurance. It was amazing because, you know what? I always thought it was kind of like 3 out of 4 of my grandparents just basically dropped dead, of a heart attack. And, long-term care insurance is very expensive. But it's also really worth it, especially if you have a spouse, right, that is going to lose a lot of their assets. And especially if you have somebody like my mother-in-law who was 15 years in need of services. But I love the hybrid plan. Have you heard of this?
Yes, absolutely.
Oh,
go ahead.
No, you explain it. Go ahead.
So I think what the hybrid that I'm referring to is that if you don't use it for long-term care, then it becomes a life insurance death benefit. So the biggest concern was with long-term care insurance, you pay your premium, and you never use it, what a waste. And then the argument is, well, you pay home insurance and car insurance, that's okay, right? But so they realized that paying month after month after month really wasn't the best way. So this is the hybrid where you're building equity in your product, but then if you don't use it, it's a death benefit. It's nice.
People are just checking in here saying how informative this is, Anne. We have a number of people here that are just saying hello. Oh no, how do I get them all? So yeah, it's great. Yeah, I loved it because, you are going to die. So, then you have the death benefit. But if you don't die, you get to use that money for long-term care, which is that's such a great idea.
Yeah.
So yeah, it's a win. It's a win-win.
It really is.
So much more affordable when you're about 60.
Mm-hmm.
And it gets really expensive, like past like 70. And then I think 80, I don't even think you can get it anymore.
Right. I think 80 is the cap on when you could get it. Yeah. And it becomes astronomical. Absolutely. So, and that's part of the educational process, right? We have to tell people, check it out, do your due diligence, do your, become a informed consumer. I looked into it. I don't like it. Next. Or I like it. Great. Right. You have to look into things.
So I made a trust during COVID. One of the reasons is because I didn't want to leave my kids with a big mess because I have a lot of businesses. So I was very concerned about them not being able to decipher what was going on with all the different businesses and the money and ownership. And so I was like, I just wanted clarity for them in a will and a trust. Is that what people use trust? Is that what a lot of people use trust for? Or
so
I thought you needed a trust to avoid probate, just even if you had a house. And so what if you have a single person and they have a home and all? Is it a good idea for them to do a trust to avoid probate if they want to, for their kids?
Sure. So again, the goal, right? We're not talking about asset protection for long-term care anymore. We're talking about either avoiding probate, whatever that means, right? Or making it easier for my children when I'm gone, right? That's a revocable trust or a living trust typically, right? You're not giving anything away. You're just putting it in a package, a trust, to make things easier, spell things out, right? Avoid probate, which means going to the court, paperwork, time, delay, and those darn attorney fees on a probate can be expensive. So let's avoid that and do the work up front so it's easier when you leave, right? When you leave this place.
You also avoid certain taxes by doing that?
No.
Oh.
No. You do not avoid taxes by the use of a revocable trust. So number one, it's revocable. So it's taxable to you. It's not, so it's all included in your estate. No tax savings. Now, trusts can have a marital trust in it, but that's a different story. And the other piece to remember in Connecticut, when you pass away owning real estate, either outright or in your trust, the state of Connecticut puts an invisible lien on your property. Freeze. Does the decedent owe us any money? And in order to release that lien, you have to file an estate tax return with the probate court. And for a fee, not a tax, but a fee, they will release the lien. So you can't avoid that. So if you have property in Connecticut and you die, you're stuck with that probate fee.
So that's a great point to bring up, Anne, because I do a lot of short sale work, and so I do a lot of title work. And people think that because their spouse died and their house is in both names, that they don't have to file that final tax return. So they're actually they're ineligible to sell the house. And they're like, well, I'm on the deed, and I'm like, oh, I know you're on the deed and you can sell it, but you have to file some paperwork with the court, and you have to do a final return. But people get so upset that they're like, this is not okay. And I'm like, this is a state. We do have some questions from Susan Salzman. She's looking forward to seeing you. So I think you're already getting a new client here. And she wants to know what is kind of the range of cost, I guess, for hiring you to start the process.
Sure. Well, personally, what I normally do is I start with a consultation. I don't know what you need. Right? I don't know if you want a revocable trust or an irrevocable trust. I don't know if you want, the Taj Mahal or, a 1-bedroom shack. So once we have an idea of what your goal is, right? What's your goal? We think about what the plan looks like, and then we can tell you what the fee will be, because they're all different. They really are different. So that's why after the consult.
Yeah, people don't know either if they want an irrevocable or revocable or whatever they need, right? They have no
They don't
idea.
know what they don't know what they don't know, right? So that's why one of my first questions when I meet with a client is, why are you here? What are your worries? What are your concerns? What are your goals? What are we talking about, right? So if I hear them say, I want to make it easier for my kids when I'm gone, I think revocable trust. If they say, I want to protect it from long-term care, I think irrevocable trust. And then we drill down and figure out exactly what the goals are.
Can you change a revocable trust when you get older to an irrevocable trust?
You can, but I probably wouldn't do it. Again, it's different terminologies, right? The revocable trust is all about you while you're alive. So we don't want that language if we want to convert it to an asset protection trust. So it probably would be a different looking trust.
Oh, but we can do a whole different trust. You could scrap the first one and do another one.
Revocable. So you revoke it. You revoke it. Yeah.
But
the nice thing,
irrevocable, you cannot.
Can't change it. That's correct. The scary part, right? It's the scary part. It's the trust in the trust. Yeah.
Interesting. My mom has an irrevocable trust, and she went to take out money, as she always does, because her house is paid off. She'd always used to just take out a home equity line of credit to redo her kitchen, to redo whatever she wanted. Well, you cannot do that because she put her house in an irrevocable trust, and now it's owned by the trustees. And now she could not get a HELOC, which she could easily go in and out of the bank and get a HELOC. And now she needed to get oh my gosh, what's it called? A reverse mortgage. That was the only HELOC they would give her, and she had to go to QM mortgage. It was very expensive. She didn't do it.
Good.
But but she didn't realize that was going to happen because you know that you actually don't own your home. The trust owns it, and there's trustees now. And she had to ask my brother and I, and we had to figure it out. And it was not
easy.
It wasn't worth it. So I think that's something good to do when you're older. And even my mom is in her 80s, but she still wanted to borrow the money to redo her house. So you have to think about when you're doing that.
Absolutely. Nothing's perfect, right? You're giving up ownership, right? You gave it away. And so we have to think about what does that mean? And it is hard to get a HELOC. Sometimes we get a HELOC before we move it into the trust, but that's another story. There's some strategies.
Sure, we answered Susan's question. So Susan, we have Anne's phone number for you. So I just want to make sure your question is answered. So let's just see if she answers. So what other incredible tips do you want to tell us? And should we be doing this? Should we be helping our parents do this? Should we be doing this at a certain age? Should we be doing this? Our divorced people, should they be doing it more? Who should be coming to you, and when am I?
Yeah. So I think really, if we take even a further step back, to me, what's the most important documentation that everyone should have is a power of attorney and a healthcare instructions, right? These are documents that speak for you when you're alive, but unable to communicate who's going to handle your finances, who's going to handle your medical decision-making. So those should be, I had my daughter, when she turned 18, I had her sign them, right? So everybody should have those documents, young, old, and in between, healthy and not. So those are kind of the starting documents that to talk about. And then, a will is important, right? A trust to avoid probate.
Can I ask you, how long are you, as a parent, the healthcare proxy for your children? Until what age?
18 in Connecticut.
So when they're 18, so if your kid is in college and they're 19 or 20 years old and they get in trouble and you're not assigned as their healthcare proxy, what's the process?
If they're not capable, then you'd probably
get into an accident, they're away in college, and now what happens?
Right. Eventually, it might be a conservatorship or guardianship in New York. But yeah, so you think about it, you can't the doctors won't give you information. They're an adult. HIPAA, privacy of information. They're an adult. Doctors can't give you information, right? You can't get any access to any medical records. So again, I strongly recommend to all families, the kids for their 18th birthday, give them a power of attorney and a healthcare document.
Wow. I think a lot of people don't realize that.
I know. It's true. I do. I know.
My daughter had an awful experience with somebody she hardly knew. So she did this early. She did this when she was in her 20s. She was teaching in, where was it? Korea. She was teaching in South Korea and teaching English for a year. And another boy that she didn't know, like from the Midwest, was also teaching, and he died. And she hardly knew him, and she didn't know his family, and his money was in a bank there, and she had to look through Facebook to get his family information. Yeah. I mean, it was just crazy. And he had no power of attorney, had no healthcare proxy, and there was no way to get his money out of the bank. And it was like a big mess, like just, he died in another country. And so my daughter came back and was doing all sorts of forms. And I'm like, what? She was like 22 years old. And she's like, Mom, I have to have all these documents and you have to sign them. I'm like, okay. But you don't think about it.
You don't.
And
I think
parents think their kids are covered while they're in college because you're still paying for them. They're still under your roof, maybe 21, but it's 18. That's so young.
18 in Connecticut. Yes. Yeah.
Wow.
I think this last year, this COVID year, we're all seeing how fragile life really is. So I've been seeing more and more people coming in to get their documents in place. It's a gift. It's a gift to your family members if something should happen, right? You just did a gift to your kids to make it easier for them. So it's lovely. I mean, it's just very helpful, and it's a form of communication too. Have those dialogues, have those conversations with your loved ones about what you see your long-term care needs are, especially as you get older, end of life decisions. Have those conversations. It truly is a gift.
And I also found out recently that a husband and wife are not each other's healthcare proxy automatically.
That's correct. That's very true. We have a default safety net in Connecticut where they'll default to next of kin, which may be the spouse, but you don't have to appoint your spouse as your decision maker. So you can appoint someone else if you wanted to. And if it's a non-emergency, they may have to do a guardianship. Spouses do not have full rights. That's true on the financial side. If you have an IRA or 401 or anything that's solely in your name, your spouse can't access that, can't get information legitimately, it's just yours. So that's why that power of attorney can be important. Access funds to support the family. They're pretty critical documents.
And also power of attorney has to be like within 3 years. They want you to keep updating it, right?
Some financial institutions get a little cranky if it's older, but the newer statute does not say that it's stale or old. So the law says it could be a 20-year-old power of attorney, should still be viable. But again, institution by institution, they may want something updated.
How do you know if there's not one that supersedes that one?
Well, I guess whose job is it? Whose job is that to give that information? So I think it's my job, if I do a new power of attorney, that I make sure the agencies and companies know it's updated. So if I send, my new updated power of attorney to Prudential now knows that the old one's void. So they have to be put on notice.
Okay, but usually you don't use a power of attorney until you need one, right? So let's say you had a ex-husband who is your power of attorney.
Right. Yeah.
And so now you want one of your kids to be your power of attorney. How does somebody know that the old one isn't still good?
Well, if you haven't handed it out, right? Are you just holding on to the documents in your box?
Oh, you don't give it to the person
I don't recommend you giving your power of attorney to your agent. It depends. But you don't have to give it to your agent. I told my daughter, I said, if you need the power of attorney, it's in the go-to box. Remember the go-to box. So,
Ah, so
right.
you
It's the
keep
go-to
it on
box.
you. You keep it all your important documents, and then she knows where to go.
Right. And the healthcare is a little different. That one, because it says if I'm terminal or if I can't make my own decisions, then. So that one I give to my doctors. It's in my medical charts. I used to carry my dad's healthcare instructions in my car or in my pocketbook because I never knew when I was going to get the call, right? Take care of my dad or mom, right?
Right, right, right.
So that one I like to hand out all over the place. And again, if you revoke it, you got to tell the hospital and the doctors, I'm revoking it. Here's the new one. So if you put it out into the universe, then it's your job to put the new one out into the universe and say, I revoked the other one.
Okay. And one last thing, can they just come to you? So let's say, my parents do their will and they trust and everything and their power of attorney with you, and I have no idea where their go-to box is. Can I just be like, Anne, you're my attorney. Do you have a copy? Is that something doable?
Absolutely. We hold our practice in this firm is we hold an original of everything. So that if the daughter calls and says, mom's in the hospital, I need the health care, I will send it over. If she says, I'm the power of attorney, I need it, I would just make sure that mom was either okay with it or mom wasn't capable, and I would send it to the daughter. So yeah, that's, a backup. We're just a backup repository for funds.
No, I would feel like it was way more of a safety net if you were my attorney and I went with my parents or my kids went with me now, and they knew what was going on and they knew to go to you.
Right.
So, they're not looking for things or wondering, I don't remember what was said 10 years ago when this was made. Like, what did Ann tell us? What were we supposed to remember? And now we're in a crisis and we don't know. It's much better to just have you as a point person and just go back to you and ask
Sure.
you.
Part of the conversation, absolutely. Now what do we do? Mom and dad did the documents. Now I'm in charge. What do I do? So, yep, have that conversation. Yeah.
So I know that the range of cost is dependent on what you do, but I know it's, a minimum of, let's call it at least $2,500, right? To start. There's some minimum.
It could be far less. I have the young couple, they have no assets or they're just going to have a baby. They need simple powers of attorney, health cares, and a will. Maybe it's $1,000 for the couple. I mean, I don't quote fees, but I don't want fees to scare people away. And if you really can't afford an attorney, then, Connecticut.gov has the power of attorney and a healthcare document online. It's better than nothing. So your Department of Social Services will have those advanced directives, the healthcare ones, hospitals, discharge planners. So they're out there. We're really, we're encouraging everyone to get these advanced directives, especially on the healthcare side, done. So get out there, get them done. Don't let a cost be a hindrance because there's ways around it. That being said, when you work with a lawyer, we kind of put some bells and whistles and talk about long-term care planning, and we add things that are a little bit more unique and personal when we meet with clients.
Oh, I'm totally for spending some money up front to save, could save tens or hundreds of thousands on the back end. You look at what happened with my mother-in-law when they just did the one line wrong in a trust. It cost them a lot of money. So, put the money up front, so you know what you're doing, and so you have peace of mind. Also, so there's no fighting amongst the siblings, because I see that so often that siblings are on different pages. And so, they have to get on the page the parents want to be on, and then it's not like they're all working, against each other when there's a crisis with the parent. It's up to the parent. It's up where the parents want everybody to be. And then everybody should comply with their wish, or the spouse, or whoever it is.
Yeah.
And you have been amazing. Well, I'm sorry we went overtime, but you've just answered so many questions. You've been such a wealth of knowledge. I love it. I just love it. So it's a tricky thing, and so many people I know are in my boat with either aging parents or aging themselves and needing your help. So thank you so much, Ann Fowler Cruz. Get in touch with Ann. It's 203-749-5570. And you do all of Connecticut, Ann?
Yes, licensed in Connecticut and New York.
Oh, Connecticut and New York. Perfect. Perfect. So do you have any last words of wisdom for us?
Have the conversation, get your documents in place, and then tuck them away and not worry about it.
Good words. Thank you so much, Ann. I appreciate it. Come back on again. So you're just
my pleasure. Pleasure. Thank you. Be well. Bye.
Thanks, Ann. Wow, we had so many people writing in and so many comments going, and that's her number. I'll leave it on the screen, and it's just a wealth of information. And if you're like me, I just don't want to leave my children confused, especially now that I'm working in the healthcare industry with seniors. I see so many kids at odds, not knowing what to do with their parents and not knowing where the money is, the funds are, how to pay for things. Excuse me. It's very important to, get all your ducks in a row. So thank you so much, Ann, for coming on. And we really, really appreciate it. And thank you for watching. And thank you for commenting. And please feel free to ask all your questions. You can get them answered here free. And until next time.
Hi, Deirdre here again. Thank you for joining me on Let's Talk Seniors Memory Care Issues. Is this an issue hitting home? Do you have a parent or loved one with memory care issues who you feel is not safe at home anymore? Are isolation, falls, and safety issues becoming a big concern? Welcome to Dogwood Senior Home, premier boutique residential senior living specializing in memory care. It's country living at its best in the Huntington section of Shelton, Connecticut. We're truly a home with only 6 senior residents living as one family unit. Senior residential homes are concepts sweeping the nation with 47,000 across the U.S. We're pleased to open Dogwood Senior Home as it will be only number 6 for Connecticut. Brand new, sparkling clean, opening mid-June. And safe. We are COVID-free. Residential care homes boast a very low COVID infection rate across the nation. This is due to the intimacy of size and speed in which the caretakers can shift to accommodate immediate needs. They are much safer than the large homes and facilities, as you can imagine. It has been documented that residents have less falls and a better quality of life in a residential home environment. Our home is more affordable than the big box facility. You pay one all-inclusive price, and that price is guaranteed for the life of the resident. With an incredible 1-to-3 caregiver ratio, which you won't find anywhere else. Our friendly, loving caregivers are dedicated and trained in Alzheimer's, dementia, and Parkinson's issues. We're only taking 6 residents, so the home will fill up fast. Call me at 203-689-7562 for a talk and tour. I would love to meet you and your loved one. See you soon. Bye.